Annex, may we have David Aguilar?
Come right up.
Come on in. Okay.
I think I may see Mr. Aguilar.
Mr. Aguilar, you need to move a little bit to your right.
Oh. Yeah,
Mr.
yeah,
We can't see Mr. Aguilar. He's off the,
it's in mute. No. Muted?
No, it's not me.
Marufo, here in the annex.
yes, sir.
By any chance, do you have the ISO number on Navidad?
Yes, sir. It's 9319503.
He's still in the classification area right now, Marufo.
He's where?
He's still in the booking section still.
He's in booking.
Yeah, he's in the booking area. Let me go get it for you. Can you give me like a couple of minutes?
Okay.
Thank you.
Mr. Vandenberg, does he have another case coming in, or how would he be in booking?
No, they just have him in a different section of the
Oh,
jail.
okay.
They're bringing him over. We can
He's
start,
not being booked.
Judge, we can continue with a plea.
Okay, which one is that one going to be?
It's on page 13, Judge. Annex, may we have Zamora, Ruben Zamora?
Just a minute.
It's actually a bond hearing, Marufo, not a plea.
Oh, I apologize. It's a bond hearing, Judge. One of the bond hearings that I gave you.
Okay. I think this may be the one we don't have a report on.
We do have a report on that one, Judge.
We do?
Yes, sir. We did.
Yes, we do. I've got it. Yes, you're right. Okay, let's go ahead and call this one. I think this is Mr. Ivy's case.
Yes, sir. We're just waiting on the defendant, Judge.
Got it. I have the ISO number on him as well.
On which one?
On Zamora, page 13, Ruben Zamora. It's a bond hearing.
Yes, did he ask for the SO number? I have it.
No, he had asked on another one.
Oh, no, he is asking on this one, I think.
Yes, for someone, please.
It's 9698268.
Ruben Zamora, he is in downtown.
Downtown. Okay, I will call them. Mr. Abbey, can you hang on? We'll get your.
Sure.
Let me see if Mr. Lopez is there. Mr. Lopez, are you there? Mr. Lopez, are you there?
I am here. I'm here.
Okay. Annex, we have Santillan Elias. That's the plea, Judge, bottom of page 12.
We have, y'all have my plea paperwork, correct?
Yes, sir.
Okay.
Do we have the plea? Have I seen that plea?
Yes, sir. I just dropped them off, Judge.
Let's see if I.
Good afternoon, Judge.
Good afternoon. I'm looking for. Yes, I've got them. Okay. Elias Santillana.
Yes, sir. In cause number 2023-0D00923, State of Texas versus Elias Santillana. Announcement of council, please.
Chantal Ortega for the state. The state is ready.
Luis Lopez on behalf of Mr. Santillana, ready.
Mr. Santillana, good afternoon, sir.
Good afternoon, Judge.
I've been told that you wish to plead guilty in this case. And I want to go over with you some rights you have that you are waiving. But first, let me ask you, are you pleading guilty because you're guilty and for no other reason?
Yes, Your Honor.
Do you understand that you are giving up your right to trial and your right to appeal by pleading guilty?
Yes, Your Honor.
Other than the recommendation that the state has made, has anybody promised you anything or pressured you or forced you to make this plea?
No, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Okay, I'm going to go through, and you've signed these, but I'm just going to go through them briefly again. You have a number of constitutional rights that you are giving up by pleading guilty, the right to plead not guilty and to force the state to prove everything beyond a reasonable doubt, the right to a trial either by a judge or a jury, the right to 10 days to prepare, the right to compel the attendance of witnesses to testify on your behalf, the right of confrontation, which means if anybody was to testify against you, they would have to do that in open court in your presence so you could see them, and your lawyer would have a right to cross-examine them, and the right to remain silent. You're giving up all of those rights. Do you understand that, sir?
Yes, Your Honor.
Okay. It looks like this is, you're going to plead to a state jail felony, and the maximum punishment for that could be not more than 2 years or less than 180 days, and a fine of not more than $10,000. There is a recommendation for punishment, and you need to understand that I am not bound by that. The state is going to summarize the evidence, and I'm going to listen to it. If I choose not to follow that recommendation, I will allow you to withdraw your plea. And you have signed a waiver of rights, a plea and acknowledgement form. And you have signed a judicial confession to the charge that you are pleading guilty to. And I'm going to ask Mr. Lopez some questions. Lopez, are you satisfied that your client is competent and understands what he is doing and is making these decisions intelligently and competently?
Yes, sir, Your Honor. My client is competent. We've gone over the case. We've talked about possible defenses, and in my opinion, this is the best option for him. He understands what he understands his rights. He also understands what rights he's giving up in order to take this plea. And in my opinion, he is doing this freely and voluntarily.
Okay. It looks like the state's recommendation to the court is 12 months of confinement with credit for time served. Is that your understanding, sir?
Yes, sir, that is.
Okay, does the state wish to summarize the evidence that it would have if this case went to trial?
Yes, Your Honor. If the state proceeded to trial in cause number 2023-0D00923, the state would have proven beyond a reasonable doubt that on the 6th day of July 2022, the defendant Elias Santillana did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight including adulterants or dilutants in the amount of less than 1 gram, and that he had been previously convicted in cause number 2017-0D02134 in the 34th District Court of a robbery lesser included offense, and that occurred on the 6th day of November 2018. And the state would at this time move to admit state's exhibits 1 through 4, which are the plea papers 3914, appeal waiver, and a virtual plea waiver.
We have no objection.
Okay, those exhibits are all admitted. Okay, there is a disclosure form indicating that the state has made a lot of different disclosures. Has the state made all of the disclosures they're obligated to make, Mr. Ortega?
Yes, Your Honor.
And Mr. Lopez, are you satisfied that they have complied with their obligation to make disclosures?
Very much so, Your Honor, yes.
Okay, there is also a certificate concerning the right of appeal. And this is a plea bargain case, so there is no right to appeal. And there is a written consent to a virtual plea, which we are doing today. So I am going to find that the evidence is sufficient, and I'm finding that you have freely and voluntarily entered this plea. And I am accepting the plea, and I will follow the recommendation with regard to punishment and sign all of the documents that I need to sign in this case. Anything further from either the state or the defense?
Nothing from the state, Your Honor. Thank you.
Nothing from defense, Your Honor.
Mr. Santillana, good luck to you, sir.
Thank you, Your Honor.
Thank you. Okay. Which one we have next?
Judge, we now have the downtown, Mr. Ivy, are you there?
Zamora.
I
Ruben.
am here.
Okay, Mr. Ives was the bond hearing for Mr. Zamora.
Correct, Judge.
Okay, let's go ahead and call that case.
In cause number 2023-0D00836, State of Texas versus Ruben Zamora. Announcement of council, please.
Chantal Ortega for the state is ready.
And I have it for Mr. Zamora ready, Your Honor.
Okay, this is set for a bond hearing for today. Mr. Ivy, why don't you tell me what the bond is and what you're asking with regard to this situation?
Judge, the bond is set at 120,000 right now. It is an aggravated assault with a deadly weapon. The deadly weapon is a screwdriver. If the court would like to hear a little bit of the facts just to get a background, my client answered an ad to be a truck driver. So he was getting into the truck and then he smelled drugs in the vehicle. Once he smelled the drugs in the vehicle, he went to the CW, the owner of the trucking company, I guess, and said, "Hey, I'm not going to be smuggling any drugs for you. This is ridiculous." And so they got into a verbal argument, and then the CW said, "I'm going to call the police." And then, so my client felt threatened, and he pulled out a screwdriver. He has no priors, Judge, from what I can tell, at least in El Paso. He does not have a place to live. He's been living in hotels. So if he's allowed to get out, Judge, I guess maybe we could allow him to live in a shelter, or I don't think he has any money to live in any hotels right now because he hasn't been working. But yes, he could definitely do a shelter until he finds some kind of income. and then he could get a place to stay and then, just work locally if the court would allow that.
I'm looking at this packet that I have been given, and it looks like there was a disposition of a marijuana possession between 2 and 50 pounds that he was found guilty of and sentenced in, I think it's Corpus Christi, the 105th District Court.
Okay,
And
I didn't see that.
there was a second similar charge. That was 1998. There was a second similar charge that was 2005, where he was also, I think he pled guilty to those. And there was, I think, a DWI in Hidalgo County. There are some other cases where there are felony allegations that I'm not sure what the final disposition of those cases were. One was dismissed. There was something in Edinburgh for a false alarm or false report of an emergency, and anyway, there are a good number of priors. Anyway, let me hear from the state with regard to their position on bond for this gentleman.
Yes, Your Honor. So for all the reasons that or all of the incidences that you've mentioned, there's also possession with an intent to distribute a controlled substance for you. It looks like from in 2003, where he was sentenced to 87 months in the federal pen. In addition, we ask that the court find the bond that is set appropriately, given that the defendant is a flight risk, as you've just described, even though he's had cases where there's been dismissals and convictions. If you'll notice, Your Honor, that all of those occurred in different places. We have Corpus Christi, Edinburgh. There was something on that occurred in Florida, for which I don't have a final disposition for that charge. And so because of that, I'm not sure, given that Mr. Ivy hasn't, told us where he would live, or if, he's at a shelter, he is a flight risk. And so because of his criminal history and because he's a flight risk and a danger to the community, the state would ask that you leave the bond at $120,000. Thank you.
Yeah, Mr. Ivy, I think what I'm going to do is what the state suggested. I'm going to not change the bond. You can re-urge this if you wish, after you may wish to do a little bit more research on your client's background, and Judge Perez may reconsider it. But I'm concerned about the safety of the community and the possibility of flight risk. So I'm going to keep the bond set at where it is.
Understood, Your Honor. I don't know. I filed a motion for an investigator on this case, Judge. I don't know if you can sign it or if you'd rather wait for Judge Perez to sign it so I can get working on that.
I've not seen that. If it is pending in front of me, does the state have a position with regard to a motion for an investigator?
No, Your Honor, the state does not object.
Okay, I will. I think this is a case where you probably should have an investigator. It looks like this could be fact intensive. So go ahead and bring an order in, see if you can get an
Mr. Hernandez has it, Judge.
and I'll go ahead and grant that, and we'll get an investigator assigned.
Mr. Ivy, I
Thank you,
do
Judge.
have that, okay? I have it ready for the judge.
Great, thank you so much.
Okay. Anything further on this case?
No, Your Honor, thank you.
No, Your Honor.
Mr. Zamora, good luck to you, sir. Thank you.
Thank you, Judge.
Okay, what is the next one?
Judge, let me confirm, downtown is that Aguilar, David?
Yes, sir.
Okay. Mr. Anchondo, are you there? Okay. We're ready on Mr. Aguilar, Judge, on page 10.
Page 10, David Aguilar. Okay, let's go ahead and call this case.
In cause number 2023-0D00319, State of Texas versus David Aguilar. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Mr. Anchondo, on behalf of Mr. Aguilar, we are ready.
Okay, this case is set for a probation status hearing, so why doesn't somebody tell me what the status of this probation is?
I think that would be Miss Pineda.
Good afternoon, Your Honor.
Good afternoon.
Mr. Aguilar's is in custody, Your Honor, due to a bench warrant. His probation started on March 21st, 2023 for 5 years straight probation. And unfortunately, he never reported to the probation department.
So he was rearrested on this charge?
He was arrested, Your Honor, on the bench warrant for the violation of not reporting.
Okay. So that is what his status is, that he is not reported at all, and that's why he was arrested.
Correct.
Okay. Mr. Anchondo, do you wish to say anything with regard to this situation?
Well, Judge, I haven't had an opportunity to meet with Mr. Aguilar. I don't know if there's been a motion filed. I'm not sure if what the recommendation of the probation department is.
Is there a motion to revoke his probation?
The motion has not been filed, Your Honor. The VN was submitted on August 8th, 2023, but no motion has been filed. As far as the recommendation from the assigned probation officer, they would continue to work with Mr. Aguilar and see about him being screened for mental health services and other assessments, since there's been no contact with him.
Vandenberg, what's your position or the DA's office position?
The DA's office is going to file a motion to revoke on this, Your Honor. And as reported, he has absolutely refused to comply with any terms of his probation. So we would be looking for a time and a revocation on this, Your Honor.
Okay, well, I think what we should do is schedule the motion to revoke and have that heard, and then figure out what we should be doing with regard to this gentleman after we hear that case. And it could be that it'll be revoked and he'll get time. It could be there will be some other level of probation. We'll make that decision when we have that hearing. But let's go ahead and get this scheduled as quickly as we can. Okay, is there anything further on this case today?
Not from the state, Your Honor.
Nothing further. I'd just like to see the revocation when it's filed.
Okay, I assume you'll be served with it. Okay, what's our next one, Mr. Marufo?
Staying with Mr. Anchondo on page 12, Judge. Annex, do you have George Roman? Thank you, downtown.
Yes, he's coming out. Roman? Roman?
Page 12?
Yes, sir, middle of page 12, Judge.
George Luis Roman.
Correct, Judge.
Got it.
In cause number 2017-0D00480 and 2022-0D00512, and 2023-0D05287, State of Texas versus George Luis Roman. Announcement of council, please.
And Tyler, take it for the state. State is ready.
Chris Anchondo on behalf of Mr. Roman, we are ready.
Okay, this is set for, looks like probation status hearings. So let me hear about what the status of his probation is.
Your Honor, Mr. Roman has been in custody since earlier this month, I believe as of September 5th, 2023. He's in custody due to a bench warrant that was requested and issued by the court due to a family violence assault rearrest that occurred on August 13, 2023. Just to let the court know, this is, I think, the third rearrest throughout his probation. Going back to the case that was originally from May of 2017. This is the third rearrest, family violence related on the same complaining witness. Earlier this year, he was, the court gave him an opportunity gave Mr. Roman an opportunity to continue on probation. His 2017 case was extended. He pled additional probation on the 2022 that ends on 0512 assault. He received 5 years straight probation on that case. And August 2023, he got rearrested once again.
All right, well, that is his status, and so he is incarcerated right now. Are there motions to revoke pending?
Not at this time, Your Honor.
Mr. Anchondo, what is your position with regard to your client's probation status?
So I have spoken with the complaining witness in this case, Judge, and she is going to sign a non-prosecution affidavit. The only reason she didn't sign the non-prosecution affidavit right away was because the statements that she gave me were such that she would possibly need an attorney of her own for the possibility of making false statements. So I advised her, to contact an attorney because the allegations or the statements that she was saying was that she hurt herself. She called the cops on her own because, or saying that Mr. Roman was the one that did those injuries, but that she created the injuries to herself. And so at that point is when I advised her to go ahead and contact an attorney so that she can make those statements fully advised of her rights as well.
Are you aware of whether she has gotten counsel?
I have not been able to contact her with regards to that, but she, well, at least I have talked to her, but she hasn't gone to seek counsel yet.
Okay, and I think you told me earlier there is not any motion to revoke pending, is that correct?
Not at this time, Your Honor.
There is not, and I'm hoping I can get this documentation to the state and they can contact her or her attorney and verify these statements.
Okay, what is the state's position as to how we ought to get this moving and get to the bottom of the situation?
Your Honor, the state is working on motions to revoke for all 3 cases. All cases involve the same victim for different offense dates and similar pattern of her asking for the charges to be dropped after the defendant is once again arrested. And because of that, the state's going to move to revoke him.
Okay, I mean, what I think probably we should do is, assuming there is a motion to revoke, we should have a pretrial hearing very quickly and have the complaining witness be there and have her be admonished by the court of her need to obtain counsel, or at least have the court suggest that she retain counsel so that she fully understands her rights. And let's get that done quickly, and then we'll see where we are at that point.
Understood, Your Honor. And will you be setting that today or when we file the motion?
Well, I think you need to file the motion to revoke first before we can set anything. But we will try to set everything as quickly as we can. And I think this is a case that should have a pretrial hearing pretty quickly, so that the concerns that Mr. Anchondo raises should be discussed openly in her presence, and she should have the opportunity to hear that and be informed before she does anything further.
I understand, Your Honor, and our office did make contact with her as recently as August 15th, when she was advised of the bond hearing that was set for that date initially. And she, didn't indicate what Mr. Anchondo has indicated here today.
Okay. All right. Well, let's stay on top of this one and get it moving.
Yes, Your Honor.
All right.
If the court is inclined to set something next week, I will be out of town, so it'll have to be past the 9th of October.
Okay. Y'all can just discuss your scheduling with Ms. Hernandez, and she'll accommodate everybody and get it set as quickly as we can get.
Thank you.
All right. Okay.
That's all I have, Judge.
All right, Mr. Roman, good luck to you, sir.
May I be excused, Your Honor?
Yes.
Thank you.
All right, what is the next one?
Page 11, Judge. And next, may we have Bojorquez, David Bojorquez.
Yes, sir, coming out.
This is Ruben Hernandez, and this is also a bond hearing.
Good afternoon, Judge.
Good afternoon. How are you doing?
Doing good, sir.
Good afternoon, Your Honor.
Good afternoon. All right, let's go ahead and call this case.
In cause number 2023-0D04731, State of Texas versus David Alexis Bojorquez. Announcement of council, please.
Edgar Reynolds for the state of Texas, ready to proceed, Your Honor.
Good morning, Your Honor. Ruben Hernandez from Mr. Bojorquez, and we're ready.
Okay, this is set for a bond hearing. Why don't you tell me what the bond is presently, and whoever is seeking to change that, I'll hear you first.
Judge, thank you, Your Honor. The smuggling of persons is a $30,000 bond. The evading arrest is $150,000 bond, Your Honor. My client is a United States citizen. He's a lifelong resident here of El Paso County. He is by profession is a welder, still has his job waiting for him, although he has been detained, Your Honor, for almost 2 months now on this charge. He has not been able to make that bond. It's much too steep. He's married, has 2 kids of his own, 7-month-old and a 4-year-old, and also takes care of his stepson, which is 8 years old. Judge, he has no prior criminal history whatsoever. I know the facts of this case are not the best facts, but Judge, he has no criminal history whatsoever. He graduated from Urban High School here in El Paso, actually graduated top 10%, Judge. He made a bad decision, got nervous, and sped away from the police and ended up in an accident. Obviously not the best decision ever, Judge, but he's a bright guy, never been in trouble, and panicked. Someone who's never been in trouble would tend to do something like this. He's not a flight risk, Judge. He's a lifelong resident here of El Paso. We're asking for a PR bond, Judge. I think a fair bond, maybe this would be a PR bond on the smuggling and on the evading. Maybe we could do, Judge, I was thinking maybe like a 5 or 10,000 cash or surety bond. I think they could post that. His family could post that. He also, Judge, has, so on this case, it's kind of weird, but it's been happening more often than not now. But on this case, Judge, the feds are also prosecuting the same charge. And so he does have a hold, some type of a hold from the feds. So as soon as he can post this bond, Judge, if it's low enough where he can post it, then the feds will pick him up and take him to federal court. And we can then get him a bond with the feds, as he has no criminal history, Judge. I'm sure they'll give us, I've done hundreds of federal bonds, and he'll have to post another bond. It'll probably be another 10,000 around there, cash and surety bond with the feds, being that he has no prior criminal history. And then he can take care of both cases as they come about. He's not set for trial in this case, Judge, until I believe March of next year. And Judge, I know the state, for some reason, wants to prosecute on this case and not let the feds do, even though the feds usually do the aid and smuggling cases, Judge. But I don't know how much experience the state has, Judge. But one of the things they have to prove is that these aliens were illegal. That's one of the, and usually what the feds do on these cases is they get the aliens and they immediately depose them. So that they have that as evidence, testimony at trial.
Your Honor,
the state doesn't have that. I'm just letting you know, Judge, because this guy's not set to a trial till March.
I'll overrule the objection. I'll hear him and then I'll hear your response. Go ahead.
Thank you, Your Honor. And so we plan to try this case, Judge. And so, because I don't think the state will be able to prove their case. And so I think that he's set for trial until March. And so they've held on to him since March. The feds never got around to deposing the illegal aliens, as they usually do, because they're usually in the feds' hands when they're arrested. But in this case, it was the state's hands. So I think the feds are also going to have problems with this case, Judge. So, and the only reason I'm saying that, Judge, is because we do plan to go to trial, and he's not set for trial until March. So we're asking the court to grant the bond reduction, Your Honor, so we can get him out on bond on both of these cases and prepare his defense.
Okay, let me hear from the state.
Yes, Your Honor. Respectfully disagree with my colleague, Mr. Hernandez. That is a misstatement of the law. The law does not require the Texas Penal Code does not require the state to prove that the individuals who were smuggled were undocumented non-citizens. If you review the statute simply states that the state must prove that the defendant was operating a vehicle to transport an individual with intent to conceal that individual from a peace officer or federal special investigator. Here we're going under the peace officer theory. We're also alleging that Mr. Bojorquez did this act with an intent to obtain a pecuniary benefit. He admitted to the DPS agents who interviewed him that he was receiving $500 per person to transport the individuals that he was transporting in his car that was numbering 6 undocumented non-citizens that he admitted to picking up near Santa Teresa, New Mexico, after conspiring with an unknown individual in Juarez, Mexico, to make the arrangements to go and pick them up. I understand Mr. Bojorquez is before this was employed as a welder. I would argue that Mr. Bojorquez's actions here show that the financial security maybe is not enough to keep him from reoffending, considering that he took on this endeavor outside of his employment. Additionally, Your Honor, Mr. Bojorquez, through his actions, has shown that he is unwilling to heed even the most basic, the the most basic commands of a traffic stop. So if he can't be trusted to pull over when an officer is lawfully attempting to detain him, I'm skeptical that he would be able to comply with any requirements placed on him by the court through the personal recognizance bond that the defense is asking for. Additionally, Your Honor, the state is pursuing prosecution on these counts under concurrent jurisdiction, along with the federal government. I can't speak to the federal prosecutors' intentions in this case. I have not yet had a chance to communicate with them and ask them about it. However, we are going to be pursuing prison time on this case. Mr. Bojorquez did place several people in a hospital when he disregarded a red light during the pursuit, placing 3 people in the hospital, including a mother and her 2 children, one of whom was a baby. The daughter of that woman suffered pretty severe injuries to her face. And so considering all of this, Your Honor, the punishment that the defendant is looking at, which let's see, the range of punishment he's looking at is up to 20 years in a state prison, as well as the fact that he fled from law enforcement. He committed this act, crossing state lines to do so. I understand he in one of the pretrial reports, he reported that he works at the Vinton steel mill, and he's been at least in contact, we allege, conspiring with foreign nationals in Mexico. So this entire criminal transaction took place across not only state lines, but potentially international lines, Your Honor. So I would say that on balance, Mr. Bojorquez may pose a flight risk, considering he's not afraid to commit crimes across state lines. So considering all of that, Your Honor, the state believes that the bond is reasonable as currently set. We would oppose any reduction to the defendant's bond.
And Judge, if I may add, my understanding is the people in the car are okay. There's no long-term injuries from what my understanding, Judge. In addition, Judge, they're asking for time on a state jail felony on the evading. That's $150,000 bond. It's a state jail felony, Judge. In addition, Judge,
3 felony.
he has no prior criminal history, and with no prior criminal history, Judge, no serious injuries reported. This is definitely a probation case. Even if we took it to the jury and he's convicted, he should not be locked up. Worst case scenario, he's going to get probation, in my opinion, Judge, with no criminal history. He was, offered to move. It's alleged that if he was offered to move these people from point A to point B for $500, Judge, he's not some type of criminal mastermind. A lot of people have been easily persuaded and to do something like this. And again, Judge, he's not a criminal with no criminal history, Judge. He made a mistake, wrong decision. And worst case scenario, this would be a probation case, Judge.
Your Honor, may I respond, please?
You may.
To clarify, Your Honor, the evading arrest charges are evading arrest or detention causing severe bodily injury, which is a 3rd-degree felony, punishable by up to 10 years in the Texas Department of Criminal Justice. These are not state jail felonies.
Okay.
Again, Judge, these are not cases that are mandatory minimums, or these are cases where you have an individual who was alleged to have transported a couple of illegal aliens who for $500, Judge. This is definitely a probation case, even in front of a jury or even in front of a judge, if we were to go that way. Again, they still have to prove, Judge, that it was done for money. There's issues as to the voluntariness of his statement, which we want to contest as well. And in addition, you have to prove that he was smuggling persons. These people that he was taking, he was smuggling. Where are they? They would have to testify to that, and they're not around. So the state has several issues, and we want to contest those before March, and we'd like to have Mr. Bojorquez out on a bond, Judge.
According to my records that I was provided with, he's been in jail 53 days already.
That's correct, Judge, almost 2 months, that's correct.
Why can we not get a trial setting before March?
The
That's-
state would be amenable to that, Your Honor.
We'd love a quicker setting, Judge, obviously. I don't know the court's docket. I'm assuming in March, we would have preference if he was detained, but we definitely want to contest all these issues. He barely had his arraignment last week, but he's been detained for 2 months, and I had to file writs and so forth, Judge, to have him indicted. Otherwise, he'd been sitting there for forever. And so we would ask for a fair bond, Judge. I think a PR bond on the smuggling and a 10,000 cash surety, I think is fair and reasonable under these circumstances. There's no criminal history. And I think at worst case scenario, even if he were convicted, a judge or a jury would likely give him probation with no criminal history whatsoever.
I would not speculate as to that. You may be right, you may not be right. What can we do? I mean, I don't think anybody, well, not anybody, but most people should not be incarcerated for as long, that length of time while they're presumed to be innocent. So I would like to see what both sides can do to get this case tried a lot earlier. I mean, if this case were to be tried this calendar year, rather than March, I think that would be advisable. Are there some reductions that the state would agree to? Or are you just saying don't reduce it at all?
Your Honor, we believe that considering the gravity of the offenses, the range of punishment, and the nature of the offense, we believe the bond is currently set reasonably.
And if I could respond to that, Judge, if those are the factors in every case that the state used, nobody would get a low bond.
Well, all right. Okay, I'm going to deny your motion without prejudice. You can re-raise it for Judge Perez. She can reconsider. She may disagree with my decision, but as of right now, I'm going to deny the motion to reduce the bond.
Okay, yeah, I will file a motion to reconsider with Judge Perez and see what we can do.
Okay, and I'd also urge both sides to see if you can get this case tried a lot faster than March.
I agree.
All right. Okay, Mr. Marufo, what's the next one?
Thank you, Your Honor. May I be excused, Your Honor?
Yes, thank you, Mr. Hernandez.
Thank you, Judge.
Back on page 10, Judge, Ayala, at the bottom. Annex, may we have Ayala, Fernando?
May I have a decimal number, sir?
It's 9620114.
On his way, Your Honor. Just give us a couple minutes, sir.
Okay.